Good morning and welcome to this session. It's Contested Heritage, Powers and Principles. I'm Richard Harwood, and this is the first of a series by the Art and Cultural Property Group at 39 Essex Chambers. We're discussing contested heritage, statues and plaques which is said by some should be removed because of the conduct or beliefs of those who memorialized. In 2020, at the height of the Black Lives Matter protests, a statue of Edward Colston, a local benefactor involved in the slave trade, was pulled down and thrown into Bristol Harbour. The Secretary of State for Communities and Local Government, Robert Jenrick, announced on the 18th of January this year that changes would be made to require planning applications where consent for the removal of such items is not presently needed, and also changes to increase the Minister's ability to call in planning and listed building applications. Joining me to consider these issues are an expert team who are just about to introduce themselves.
Hello, I'm Antonia Layard. I'm a professor of law at the University of Bristol.
Okay, thank you, Antonia.
Hello, I'm David Sawtell. I'm a barrister at 39 Essex Chambers, and I specialise in landlord construction disputes and had some experience of matters involving quite heavily contested issues around ownership issues and rights.
Good morning, I'm Catherine Dobson, a barrister at 39 Essex Chambers.
During today's session, we will have a Q&A going, so please do enter questions on the Q&A box, and we'll try and pick those up in the discussion as we're going along. But we're going to start with Catherine looking at the listed building aspects.
So good morning again. So what we thought we'd do in the first part of this presentation, the seminar, is to go through the sorts of issues that you will need to consider if you are considering removal or alteration of a statue or memorial. And the first set of considerations we're going to look at are those related to listed building control. So if we move to the first slide, the first thing that you're going to need to consider is whether listed building consent is required. And there are 4 points to consider here. The starting point will, of course, be to consider whether the statue or memorial is listed in its own right. And that task is made much easier than it used to be because Historic England now has a searchable electronic database. So, for example, if you were to search statue of Edward Colston, or if you were to search now, you would find an entry showing that it's a grade 2 listed building. And you'd also find the reason why it was listed. I won't go through those now, but the reasons for listing are important to some of the issues that we'll be considering this morning. Now, if the statue or memorial is on the list, that may not be determinative of the matter. An issue may arise as to whether the item is in law capable of being a listed building. So this is the second question that you will need to consider. This issue was ruled upon by the Supreme Court in the Dill case last year. So in that case, the question was whether or not 2 18th century urns, which were listed in their own right, were capable of being buildings. Now, the Supreme Court did not determine that question, but it did rule on how the issue is to be approached as a matter of law. And the Supreme Court held that whether something is capable of being a listed building should be approached in the same way as it is in planning law, applying the so-called Skerritt's test. So in the Skerritt's case, the question was whether a large marquee was a building for planning purposes. And the court said this question was to be judged by considering its size, permanence, and degree of physical attachment. How this test is to be applied to statues and memorials will always depend on the facts of a particular case. We could stay on the earlier slide, please. There is, however, some useful guidance in the judgment of Lord Carnworth in Dill. He considered a number of examples of listed statues and monuments given in Historic England's listing selection guide for garden and park structures. So, for example, he considered Henry Moore's Grade 2 star listed reclining woman at Dartington Hall. And he pointed to 3 factors suggesting that it could be a listed building in its own right. These were that it was resting on its own weight, that the plinth was a substantial built structure, and that the plinth and the figure together appeared to form an integral design for the site in which it was placed. Lord Carnwath also considered the Grade 1 listed Crystal Palace dinosaurs, and he concluded that given their size and permanence, they could reasonably be seen as buildings in their own right. Now, as I said, the Supreme Court did not decide whether the urns in question in Dill, one of which is pictured on the slide you see there, he didn't decide whether, well, the Supreme Court didn't decide whether they were buildings or not. He said this was a matter for the inspector on redetermination. But he did comment that most ordinary forms of garden vase or seats would be unlikely to be regarded as a building applying the planning law test. Now, if we go to the next slide, if the statue or memorial is not listed in its own right, the third question to consider is whether it is an object or structure which is to be treated as part of a listed building under the extended definition of buildings in Section 1.5 of the Listed Buildings Act. And there are 2 parts to the extended definition. The first one applies to objects placed within the curtilage of listed buildings before July 1948. And if an object was placed within the curtilage of a listed building before then it will be covered by the listing. If the curtilage provision does not apply because the item was placed there after 1948, the question is whether the item is fixed to the building within the meaning of Section 1.5a of the Act. And the Supreme Court in Dill has confirmed that the question of whether or not an object or structure is fixed to a building for the purposes of Section 1.5a is determined by applying the 2-stage property test. And that is, first of all, to look at the method and degree of annexation, and secondly, to look at the object and purpose of the annexation. Now, again, whether or not a particular statue or memorial or plaque is fixed to a building is always going to be a question of fact in an individual case. In the Tower Hamlets and Bromley case, the court concluded that Henry Moore's old flow was not a fixture, in essence, because it was resting on its own weight, it could be removed without damage, and it was not in any sense dependent on its location for its appreciation. And David's going to consider that case in more detail. That's potentially of relevance when looking at statues in this context. When it comes to plaques, it may well be that a plaque affixed to a listed building falls under the extended definition. Whether it does may depend on the method of fixation. Some plaques, as I understand it, are surface mounted, so could quite easily be removed, whereas others are inset or embedded into the building, which is going to make removal more difficult and have more of an impact on the building to which it's fixed. Go to the next slide. If the statue or memorial is listed in its own right, or it falls under the extended definition of a listed building, the fourth and final question is whether the proposed work requires listed building consent. Now, under the Listed Building Act, consent is required for demolition or for alteration or extension, which would affect a listed building's special character as a building of special architectural or historic interest. So interesting questions can arise here. Again, they'll all turn on the facts of a particular case, but for example, whether a statue fixed to a plinth or to the ground, the work involved in removing it amounts to demolition. It's not at all straightforward. Whether or not alterations require listed building consent is highly fact sensitive. It depends on whether the alterations would affect its special character as a building of special architectural or historic interest. So if you consider the example of affixing a plaque, perhaps to explain the statue or its provenance as part of the retain and explain policy, this may or may not require listed building consent. It will depend on the plaque's design, its positioning, how it's fixed to the statue or memorial, and overall how it's how its addition will affect the special character of the building, affect its special architectural or historic interest. Another question that could arise in this context is whether removal or relocation of statues and memorials requires listed building consent. Some statues which rest on their own weight, as we saw in the old flow example, can simply be removed without any damage to the statue or to the plinth on which it rests. But whether it requires listed building consent is likely to depend on whether the relocation will affect the statue's special interest. Looking at the old flow case, in that case, the judge said that the appreciation of the statute was not in any sense dependent on its location. But by contrast, if you look at the listing for Reclining Woman at Dartington Hall, that refers to the specific situation of the statue in the gardens where it was originally placed as of particular architectural interest. So it's going to be fact sensitive. And finally, we go to the last slide. If you conclude that listed building consent is required for the alterations or relocation that is proposed, then you have a number of options. The first is to make an application for a certificate of lawfulness under section 26(8) of the Act on the ground that the alteration or removal of the statute would not affect its special historic or architectural interest, so that listed building consent is not required. The second option would be to make an application for listed building consent under section 10 of the Listed Buildings Act. And in both cases here, the question is going to be whether or not the proposed works to the listed building would affect its special historic or architectural interest. And ultimately, this is going to be a matter of judgment for the decision maker. And what you're going to need to do in considering this issue is to, first of all, identify the special interest of the building. And the list description is the usual starting point for this. You may also need to engage the assistance of an expert to comment on the impact of the proposed works on that, on the special interests of the building. And then finally, the third option is to apply the delisting. And I know this is a process that Professor Layard is going to talk about, so I won't go into that in any detail here. And that, in outline, is the listed building considerations that may arise when altering or removing a statue or memorial. I'll pass over to Richard.
Catherine, thank you. And the listed building regime is relatively straightforward and clear in its application. And the changes which Robert Jenrick announced, which we'll see the implementation of fairly soon, of a limited impact in listed building terms. The main one is that the notification requirements to Historic England and National Amenity Societies will have to be broadened, because at the moment, notice is only required of changes to grade 2 listed buildings if it's demolition of the principal building, and some of these removals may be in the context of alterations. But planning control is a little bit more complex, and the legislative changes are really going to be coming into that situation. So if we look first of all at whether planning permission is needed, firstly, I mean, is it actually part of a building or a building itself, something where an alteration to it amounts to operational development? Now, whether it's building or part of a building is going to be governed by the principles which Catherine was talking about, the Skerritt's test on buildings and the questions of fixtures. You may have something which is part of a building, but is excluded from the definition of development, so it doesn't need planning permission. And most obviously, those are internal alterations, and also any change which has no material effect on the external appearance of the building. Now, there's no intention in the announcement to change those principles. Where the controls become even weaker, in a sense, with even less application at the moment, is that demolition of a building does not need planning permission if the building itself is under 115 cubic meters in volume. That's outside conservation areas. So most statues which we're looking at are going to be a lot smaller than that. So one change which can be anticipated is that demolition direction will be amended so that memorials and statues coming into whatever the particular formulation is are going to be caught by the definition development, and so would need planning permission. But we move on then to look at conservation areas. Conservation areas, as many people know, have a particular definition of relevant demolition. If you carry out relevant demolition without consent, then that's an immediate criminal offence. That has a size restriction to it. I think I've flipped them round the wrong way, I'm afraid. So in relevant demolition is 115 cubic meters, but there's a 50 cubic meters limit for demolition being development in general terms. Still both far too sizable. There is a further exception in conservation areas that something which is relevant demolition is the removal of a pre-1925 tombstone. And that means a monument or memorial to a deceased person which was erected before 1st of January 1925. It's not actually tied to their grave. So many of the contested heritage, where we're looking at sort of Victorian era statues, for example, if they're in conservation areas, they would be pre-1925 tombstones, and so planning permission would be needed for their removal pursuant to the conservation areas regime. In some examples, one here isn't contested, but a distinctly underdressed rider for present weather circumstances. So firstly, do you need planning permission? And it will be different in and outside conservation areas. The second check that follows is about permitted development, because if you do need planning permission, very often that will be granted by the permitted development order. First question you have to ask yourself is, are you dealing with demolition of a building, and that's the whole of the building being demolished, or simply an alteration? If it's demolition, then that will ordinarily be covered by the Part 11 Class B rights. They don't apply in conservation areas, they don't apply to pubs, but otherwise they authorize the demolition of a building subject to a prior approval process being gone through. Now, again, for the minister to take control, to require a planning application to be made, those provisions will need to be amended such that these contested heritage categories don't fall within those demolition rights. The second possibility is an alteration, and that may well be a situation where you have a plaque on the front on a building, or a statue or a work of art attached to a building. The removal of that would not be the demolition of the building, but it may well be an alteration. And there are a wide range of permitted development rights dealing with alterations which could apply. So potentially householder rights, removing blue plaques, officers, some educational institutions, which may be important. Rail undertakers have quite wide permitted development rights, although it's probably not really going to get us into the contested heritage category too much, since, as far as I can tell, most of the statues in railway stations are of Isambard Kingdom Brunel, so who hasn't yet been caught up in the controversy. It is possible to remove those permitted development rights on a local basis by Article 4 directions, but I suspect that that is going to be rather superseded by the changes which are going to come forward. So if I just want to sort of pull together those changes, and the Secretary of State set out in a written ministerial statement on the 18th of January that the removal of any historic unlisted statue, plaque, memorial or monument should be subject to an explicit requirement to obtain planning permission. And to do that, there are a variety of stages. One will be to amend the demolition direction to make that all development, potentially with that amendments to the conservation area provisions. There will need to be amendments to the general permitted development order in respect of demolition and alteration, so that those works no longer have permitted development rights. The provisions for notice of planning applications to Historic England and to the National Amenity Societies like the Victorian Society and 20th Century Society will need to be changed in the Development Management Procedure Order so that they know of these applications. And from the written statement, the Secretary of State envisages that he would be told of applications which are proposed for approval, which are subject to outstanding objection from Historic England or those amenity societies. And that would lead to a change to the consultation direction 2009. So those are the changes which we can expect in the legislation. Those are all matters of directions or secondary legislation. No primary legislation would be changed, and from the statement, it's not envisaged that there will be any alteration to the general scope of planning or listed building control to follow. But this is what we'll be sort of looking at. And now pass to David to take us on to some other issues.
What I'd like to do is spend a few minutes looking at the personal property issues in these cases and the real property, the land law issues. So far, we have been considering matters relating to public law, but as we all well know, there are going to be questions as to ownership of items, and this might very well depend on whether an item is said to be personal property, a chattel, in other words, or whether it's said to be part of the land itself. And these private law questions have their own distinct rule set, which may or may not coincide with the public law tests that Richard and Catherine have outlined. What we have on this slide here is a statue by Henry Moore, a draped woman seated, created in 1957. It is a substantial object. It weighs 1,500 kilograms. And it was cast in an edition of 7 in the 1950s. And one of them, cast 2, is owned by the London Borough of Tower Hamlets. And this is the case that Catherine was referring to earlier in this webinar, because when it comes to private law questions, private law issues, the actual ownership of these objects might well be hotly contested, or it might not be contested at all. It might simply be unknown. The question of whether or not an object has become part of a land, whether it remains a chattel, is dealt with in the House of Lords case of Elitestone against Morris. And that was a case about a house and whether the house was being erected in a certain way using modular construction remained a chattel or whether it had become part of the land. And those considerations have often been applied across a whole range of different objects. So we have questions as to industrial installations, plant, mechanical and electrical installations, and it's complicated by questions of removability. Even if an object becomes part of the land, so it ceases to be a chattel, and ownership of the object now passes to the owner of the land, there might still be a question as to whether a party has a right to remove it from the land. So, for example, if a tenant installs a trade fixture, there's a question as to whether or not a tenant or a successor entitled can remove that item. And part of that analysis is also a question of those who have life interests. And it's not unknown at all in the case law for an object to be installed and for it to become part of the land for the question of the Elitestone test, but then for it to be subject to a right of removal by a tenant for life interest. So these questions have complicated and at moments obfuscated the case law, particularly in relation to art. And we have a series of cases which have been acknowledged to not be entirely on all fours with each other, but they typically turn on the object of annexation. As Catherine outlined, when we come to questions of real property law, there are two parts of it. First of all, the question of has it been affixed to the land? And of course, if something has been substantially affixed to the land, then the burden of proving it remains a chattel rests with the party who says it isn't part of the land. But of course, a statue or a tapestry or many other objects might be very likely attached to the land. And the primary test in many of these cases is the object of annexation. Are they part and parcel of the design, for example, of a house and gardens, or are they only affixed for their better enjoyment as chattels? So to take the first case at Lee and Taylor from 1902, that was a case about tapestries. Those tapestries were tacked to matchboard, and the matchboard itself was nailed to the wall. So at one level, it could be seen that these tapestries were quite highly annexed to the land, quite firmly affixed. But it was held, in fact, that they remained chattels because such annexation was necessary to enjoy the objects as chattels, rather than because on objective interpretation, they were intended to become part of the land. So immediately, a case such as Lee and Taylor shows us that the battle lines are extremely unclear and that each case is going to be highly factually specific. The next case of Kennedy against Secretary of State for Wales illustrates that. So we have a Crillon clock, rests on its own weight, but is held to be part of the land because it is part of the design of a historic house. So the pseudo-Gothic design of the building itself was purposely designed to house the clock. And it was designed to harmonize with the architecture and the materials. So we can see, although in question of a physical annexation to the land, it might not count so highly on that part of the test, but in terms of the object of annexation, it was indeed part of the land. The next case, Barclay and Pullett, illustrates how these disputes might arise. And the photograph gives the game away. Hinton House was going to be sold, but perhaps unknown to the purchaser of the house itself, parts of the contents were going to be sold separately in different auction lots. And so we're talking about a very substantial statue. It was a white marble statue of a Greek athlete, which weighed approximately half a ton, and it stood on a plinth. And it was held that that actually remained a chattel. The plinth was there simply to harmonize it with the rest of the garden. You could, in fact, put something else on that plinth. Again, a sundial rested on a pedestal that remained a chattel. And the comment by Lord Justice Scarman on this slide illustrates the question. Was it a fixture? Well, it was cited to form an integral part of the design of the west elevation of the house. So you might well think that we're back into Secretary of State of Wales case. But what you put on the plinth was very much a question of taste for the occupier. And it comes back to, was it there for better enjoyment of being a chattel? Yes, it was. And going back to that plinth, the object it carried could be whatever appealed to the occupier for the time being. So let's get back on to Old Flow and the London Borough Tower Hamlets case. And in this case, there was a dispute about the ownership of this particular statue. And when it was originally installed in the early 1960s, there was originally a great deal of hostility towards it. But that quickly dissipated, and it was soon seen to be part and parcel of what was quite an interesting, architecturally interesting and significant estate. But the statue itself had a rather lengthy property history to it. Originally, it was London County Council who acquired the statue, and they placed it in Stepney. After that, of course, London County Council went on to become something else. And Mr. Justice Norris held this statue, in fact, despite its significant weight, was not part of the land and did not form part of an integral design of that estate. Looking at its history then, however, the LCC became the GLC. The statue vested in the GLC, and then it went on to be owned by the London Borough of Bromley. But Tower Hamlets dealt with the statue in a number of ways with this personal property, and has held that they had converted it to their own use. And by way of the statute limitation, Bromley's title to it had been extinguished. Now, there's some controversy about the way in which that title had been extinguished. First of all, it had been removed from its original site. And for example, at one stage, it was loaned to a sculpture park, and it was said that this was part of the acts of conversion. Now, is that right? Are they actually dealing with the sculptures or statue itself by moving it, in that case, up to Yorkshire to a different sculpture park? They also undertook restoration work to it, and that was also held to be one of the acts of conversion. But the argument, a counter-argument to that is, of course, you're simply maintaining its situation and keeping it in and restoring it rather than actually substantially modifying it. So it does lead to very complicated issues as to ownership. So if we have an item that has been removed from the land, or if it remains personal property, it raises issues as to charity law, and if it goes into a museum, as to whether the museum is acting as a custodian of it and is not affecting any property ownership in it, or is there a line that one crosses where the museum has converted it to their own use? But what if you don't even want this object? What if any objects going into a museum need to be looked after carefully? And I have a picture there of the proposed British Museum Archaeological Research Collection. Extremely expensive, architecturally significant project, raising its own property and construction law issues. Essentially, it's an expensive undertaking to retain and to look after these objects. And if you don't know who owns it, then that can only complicate the issue altogether. But if the object is not personal property, if it's actually part and parcel of the land and it's on public display, then who owns the land? Who actually has a private law right to take it away? And does that conflict with any public law rights? So what this part of the webinar, I hope, suggests is that notwithstanding any public law issues, there is a rich tapestry and a rich matrix and a separate rule set in terms of the private law ownership and any bundle rights associated with the private law ownership of these particular objects that need to be considered with some care, whether or not there's a contest over it. These are objects and those private law rights need to be respected. I'd like to hand over to Antonia now.
Thank you, David. So I'll take us back to Edward Colston, who is now no longer on his plinth, and ask whether we might have delisted him or delist him still. So next slide, sorry, David. We clearly can delist. It's a power under the Act. The list can be amended to be done in consultation, and the statutory criteria are whether the statue would still have historic interest. So this was last drafted in 2019, and I'd suggest may want to be updated rather to take account of these questions of contested heritage. So the criteria are of national importance, whether the statue in its current form will afford a strong connection with the valued aspect of history. So there are words there that we might want to interrogate further, value and in its current form, when considering whether or not to delist. But under the criteria as they stand, you can see why it was considered difficult to delist a statue such as Colston. And if we think about Colston's empty plinth, next slide, please, David. That brings us to thinking about the connection between statues and the public realm. So many will know of Caroline Criado Perez's campaign to increase representation in our public realm, particularly of women. In one study, she found that around 2.7% of all statues were of women who were neither royal, mythic, religious, or nude. We have significant underrepresentation of certain types of people. And the question is how we can marry listed building and the creation and reinvigoration sometimes of the public realm through the use of statues or other forms of art. So just in the background, I wondered whether people generally knew which statues were on the 3 plinths in Trafalgar Square. I confess I had to look it up. I had a vague idea about one, but the other 2 I wasn't sure about. And the reason for this question is that they're occupying pretty prime real estate. So if we are not sure who these people are that are occupying the plinths in Trafalgar Square, do we want to keep them there in perpetuity, or might we relocate them? And that's the question we come to consider now. So purely as a thought experiment, I'm quite fond of this statue, but the statue of Burke in Bristol. So Burke is also listed here as a grade 2. He's quite close to where the Colston statue stood in group value according to the Colston reasons for designation, with the cenotaph and with the drinking fountain. There's very little on the reasons for designation. I've given you all that there is. In 77, all 4 items were listed together as grade 2. So next slide, please, David. If we think about Burke, Burke was an Anglo-Irish statesman who came to Bristol and represented the city for 6 years. Initially, the historians tell us there was a red-hot attraction between Burke and the city, but this cooled quickly on both sides. So in his speech to the electors of Bristol in 1774, he put forward his theory of representation, which was that he would go to Parliament to work on the common good, leaving local prejudices at home. So it was a theory of representation which really demonstrated that he wasn't that keen on Bristolian voters at the time. Now, this is purely a thought experiment. My colleague Chris Bertram at the university makes a very cogent argument why we should definitely leave Burke standing, which I'd recommend you read. So it's a fascinating piece. But imagine for a minute we were going to relocate him. Could we do so under the existing listed building regime? So the authority we'd want to turn to is Judge. And Judge, both at first instance and Court of Appeal, held that relocation was simply a convenient shorthand for demolition and reconstruction. So in Judge, there was a statue of Sir Samuel Sadler in Middlesbrough. And Middlesbrough Town Council wanted to redesign their public square, building an art gallery, and they had a regeneration project of £20 million. And they applied to English Heritage in the normal way, giving notice as required, requesting permission to, first of all, demolish, but then immediately reconstruct with a condition under Section 17. And this was opposed by a litigant in person in Judge, who argued first that when the statue of Samuel Sadler came down, and it was at the time of the litigation being carefully looked after and restored, when that statue came down, that it was personalty, not realty, and so no longer subject to the listed building regime. Justice Sullivan makes pretty swift end of this argument and says, no, it's still covered by the listed building regime, even though at that time it is no longer affixed. The second question is whether relocation, even though that term isn't used in the Act, could be covered in this way. And both at first instance and in the Court of Appeal, Lord Justice Buxton confirmed that relocation can consist of demolition and reconstruction. So Section 7 and 17 together. Next slide, please, David. Thank you. So if you were to relocate Burke, say to a nice museum of politics and political theory, sorry, no, back. There we go. So we're going to put Burke into a museum and we're going to have him in a museum there, and we can relocate him. So that was the authority of Judge. It's also in a separate authority of Hobson, considered there at some length where over-enthusiastic dismantling of a barn meant that it wasn't clear whether there was demolition and then reconstruction, and whether how many bricks were used of the old barn and the new barn and the precise details. So Judge wasn't cited, even though it was directly on point. But again, the court in Hobson determined that Section 7 and 17 together, a relocation could be covered under the regime. Permission would only need to be given once, even if there's some delay between the taking down and the reconstruction. So for the Sadler statue in Judge, it was a year, and there's an indication in Hobson that several years would not suffice. But in principle, as long as the time between the taking down and the putting up again is not too long, relocation could be provided for under the Act. So if we wanted to move Burke, we would look for the reasons for designation. As I've shown you, they're pretty short. In City of Edinburgh Council, the House of Lords told us that the reasons for listing are significant, but they concentrated much more on what is listed, what is within the curtilage, rather than why it is listed. So the listing documentation matters, but is often somewhat short. So that would leave us turning to the NPPF. So these are the new proposed paragraphs. Oh, sorry, David, just back one slide, if I may. So paragraph 196 tells us that we should consider the desirability of sustaining and enhancing the significance of heritage assets and putting them to viable uses consistent with their conservation. So we could make an argument that Burke should go into a museum on political theory and politics, and this would be a viable use consistent with its conservation. But all the time we're working against a regime that really isn't drafted for these kinds of questions. In the decision on Lempster, where the antique barn was dismantled, the then editor of the Journal of Planning and Environmental Law noted that the wording does not really fit. We're trying to make a system of legislation and case law work to answer questions which it wasn't really designed for. Next slide, please, David. So this brings us to the proposed paragraph 197. So this is retain and explain. And this tells us that when considering any applications to remove or alter a historic statue, plaque or memorial, whether listed or not, LPAs should have regard to the importance of retaining these heritage assets and, where appropriate, of explaining their historic and social context rather than removal. So it's this is one of the paragraphs currently up for consultation. Retain and explain. Next slide, please, David. So what does have regard to mean? In the decision of Howell at first instance, Justice Cranston told us that have regard to means simply that the matter must be specifically considered. Not that it must be given greater weight, and not that it's a trump card. And it doesn't impose a presumption in favour of a particular result or duty to achieve that result. So retain and explain wouldn't necessarily mean that Burke has to stay where he is. Other matters may outweigh the principle in the balance of decision making, and on careful consideration, the matter may be given little, if any, weight. That's in first instance. In the Court of Appeal, Sir David Keane briefly approves this, just saying that have regard leaves scope for some divergence from national policies. So it's only one factor, retain and explain, as currently drafted. So if we were going to move Burke, we would look to section 16.2 of the Act, so special regard to the desirability of preserving a building or its setting. And in the draft 8B, we have as a social objective now, fostering well-designed, beautiful and safe places. In 193 and 194, again, there is a focus on setting. So it's worth considering very briefly setting. Imagine we were to have a statue to the Bristol rugby team, and we were going to put this statue to the Bristol Bears in front of the stadium at Ashton Gate. And we might think that's a fine statue in its setting. But imagine we took that statue and we took it a few miles down the road to the riverbank in Bath, and we put it in front of the wreck, perhaps with the numbers 48.3. We would expect that statue to be desecrated fairly quickly because it's in the wrong setting. The context has changed. And the point here is that there is always an interaction between the statue and the context. And that is really what we're getting at with setting. And even if the statue stays the same, the location may stay the same in terms of GPS, but its contents, the type of people, the society we live in has changed around the statue. And that dynamic relationship between the statue and its context is what I would suggest we need to consider when we're thinking about setting. Next slide, please. Thank you, David. So I would suggest that we should be much keener to have local statues for local people, with local people involved in decision making, perhaps through the planning process. I think there are many fine local statues that now have space to flourish, but we may have to reconsider which statues are already in the prime spot. So this is people like us in Tiger Bay in Wales, if you haven't seen it. But there are many fine local statues that draw on the global and the regional and the national. So local may mean parochial, but it may not. I think we have, if we connect the listed building regimes to public realm, we have opportunities to think much more creatively about a diverse and truly representative, dynamic system of heritage. Next slide, please, David. So this brings us to the plinths. Perhaps you knew this, Henry Napier, George IV and Charles Havelock. They occupy the plinths. I didn't know that, perhaps you did. But I think it goes to show that we have men on plinths that we aren't necessarily all that informed about. And if we were starting again today, we might not necessarily put there. Last slide, please, David. Oh no, penultimate slide, apologies. This is the fourth plinth, much more representative of London today as a dynamic global city. We may not like all of them, we may not agree with all of them, but it is a good representation of art, which is obviously quite different from representation of statues, but shows us what we could use plinths for. Now the last slide, please, David. Which brings me just to end with Edward Jenner. So Edward Jenner, you all know, was a pioneer of vaccination. You may know that he initially had a statue in Trafalgar Square. In 1826, this was unveiled by Prince Albert. However, when Trafalgar Square was remodeled in the later 19th century, his statue was moved to Kensington Gardens, where it sits now, because it was said to be out of place. So Trafalgar Square was for military characters sitting aside horses, and Jenner was thought not to be appropriate for Trafalgar Square. Now in 2021, I would suggest there's probably no one we'd want to honour more than Jenner, and perhaps bring back to Trafalgar Square. But to do that, we really need to think about relocation and have a dynamic and progressive approach to listing. Thank you.
Okay, Antonia, thank you for that. And we're going to move to discuss cultural heritage and contested heritage in general terms. Antonia, you're academic at professor at Bristol University. You've written specifically on Colston. I don't know if you were there when he got tipped into the harbour, but why is contested heritage so contested these days?
I think I would point to three factors. One would be change. We're not particularly comfortable with change, many of us, certainly me. I'm not great with change. And so we have change in society while the statues stay the same. In the case of Colston, of course, the statue went up 170 years after his death. It was paid for by the publisher Arrowsmith. There was some public subscription, but even then they couldn't get enough money to put it in place. But if you were to put a statue of Colston up today, you would never get permission. So one reason I think contested heritage is hard is because of change. Another reason is I think because of local and central decision making. So I think you will find people in Bristol who are disappointed that Colston has gone, but the vast majority of us, at surprising numbers, are incredibly relieved. There is an air of relief in the city, which may not be obvious if you're not that involved with Bristol. And the third reason it's contested, I think, is because the listed building framework just doesn't really work in relation to these kinds of statues. And at some level, the idea that a statue is a building, while absolutely confirmed in case law, goes contrary to common sense. And I think we probably need a more nuanced way of thinking about it that really engages with these difficult questions of contested heritage.
Is that looking at a rather sort of different approach to statues as something that are potentially rather sort of transient rather than permanent because they happen to have been there?
Is that to me, Rich? Sorry,
yeah,
apologies.
Yeah.
Yes, I think the world changes, doesn't it? And who we would put up today, and we would maybe put up, so there are statues going up. I mean, there's statues of Virginia Woolf, there are statues of Mary Wollstonecraft, very notably. So we are putting up more statues, and I think many of us would welcome more statues. We're always happy as Bristolians to see statues of Brunel in various places of honour. But the question really is how we engage with dynamic public realm and statues that don't change once they're set up, and if they become listed, where the whole regime is designed towards their preservation more than perhaps their relocation. I would argue that relocation should be viably considered as it has been in other times.
Yeah. I mean, it seems to me another aspect of why contested heritage is becoming so contested is simply as an aspect of our history, that there is so much of it is significantly looked at in different ways, but it also reflects contemporary political debate. And probably one of the issues that comes here is the extent to which you're seeking to deal with land use planning issues and dealing with the historic environment and separating that to the extent there is, an extent to which there's overlap, with what are current political issues, which potentially can be addressed another way. Now, one aspect of listing is the historic interest of objects. And does it make a difference that the person who's memorialized may have been associated with the slave trade, or in another example, there's criticism because of their role with empire? Catherine, what are your thoughts on those?
Well, I don't think I'm qualified to comment on the sort of philosophical elements of whether someone's actions and how they're perceived, and how the perception of them is changes over time, is relevant to its historic interest. But from a legal perspective, I think what is important to think about is how that might be relevant to applications to, in the case of a memorial or a statue that has got listed building status, an application to for permission to remove the statue, or indeed to delist it. And one of the key things that a local planning authority or the Secretary of State would consider is whether there's any new information available since the statue was listed that could lead to a change in the basis on which it was listed, the historical interest. It's going to be a question of judgment whether changes in perception of the historic value of the individual memorialized affects that in a significant way, so that it's appropriate to grant permission to remove the statue or alter it, or if it's indeed appropriate to delist it. But I certainly think it's, from a legal perspective, arguably relevant.
Yeah, I also slightly wonder as to where potentially it goes, partly because some of the people of greatest historic interest tend to be the real baddies. I mean, Richard III is the sort of good example. If it was Henry III who was buried under the car park in Leicester, then Henry III reigned for 56 years. As medieval kings go, was actually quite pious and not actually a completely nasty individual. Richard III was there for 2 years and had an atrocious reputation, which is why the interest was there. So being saintly is not sort of connected to it. But what does seem to me to be one issue is, as Catherine says, there may well be an effect on historic interest, but very often the reason statues, particularly from the Georgian or Victorian areas are listed, is actually because of their architectural or historic interest, and that's picked up by the Historic England Selection Guide on commemorative statues, that it is very often that architectural interest, or the way in which they fit into the context, which is the reason for their being listed. I mean, there are some examples which are personal. In fact, some graves of slaves or former slaves are amongst those which have been listed for that very particular reason. But the character of the individual in listing terms is probably a fairly marginal point in most of the examples, and that does feed through to how we then look at the issues. We've been having a few questions in, and thank you for everyone who's sent those in our Zoom discussion. One is in relation to the two different tests which come out of the Dill decision in the Supreme Court, which is that where you have the question, is something a building, particularly when it can be listed in its own right, you apply what is referred to in shorthand as a Skerritt's test, looking at permanence, degree of attachment and size. And if you're concerned with whether something is part of it for land law purposes and also includes fixtures and curtilage objects caught by listing, it's applying the old land law tests of purpose and degree of annexation, and questions to what extent that distinction, which the Supreme Court devised, is actually problematic in practice. I don't know, perhaps Catherine and David, you want to sort of come in on that one?
In terms of being problematic in practice, I would have to wholly agree. It's a frustrating test to apply, and I think the art examples illustrate that, because you can have what are superficially almost exactly the same object, but because of their setting and the intent which will be placed, you can arrive at a completely different result. Because whether or not something remains a chattel or it becomes part of the land is a binary test. It's one or the other. We don't have an intermediate stage. If it becomes part of the land, there might be a question of removability. And that is illustrated again in the question of statues. Sometimes the statues, we don't have to look at the statue. We should look a few meters lower and look at the plinth. Often there's actually the plinth, which is the determining factor. I don't know so much about Havelock. I know a little bit more about George IV, but that fourth plinth was never labelled, of course. And that's what's determining what goes on top of that plinth. And often for a landlord purpose, we're going to be looking at the plinth rather than what goes on top of the plinth. Whereas in the public realm, in the public space, we're much more concerned about what's visible, what we can actually see on top of that plinth. We are always going to have arguments about the extent to which something is affixed to the land and its importance vis-a-vis the object and purpose, particularly where we can't even specify it contractually or in some other documents. We're simply looking at the intent. But certainly from a landlord perspective, it probably will not be resolved. It's certainly been going since at least the early 19th century. And if not before, you can trace the origins and the arguments into the 18th century as well. I don't think it will be resolved while it's in its current form.
Okay, Catherine, any thoughts?
Well, in the Dill case, this was an issue, whether or not the Skerritt's test or the property law test should apply for the purposes of determining whether something is capable of being a building for the Listed Building Act. Richard and I appeared in that case on behalf of the appellant and had argued that our primary case was we should apply the property law test, which wasn't adopted by the Supreme Court. And Lord Carnworth said the reason why they thought the planning law test should be applied for the purposes of the Listed Building Act is that the Listed Building Act takes the definition of building from Town and Country Planning Act. And so it was more coherent to have the same test applied for the purposes of the Listed Building Act as applies for the purposes of the Town and Country Planning Act. And you can see there's a coherence there. What we also argued, however, was that on the facts of the Dill case, it wouldn't have made a difference whether you applied the planning test or the property law test. And on the and obviously the application of both tests involves a mixed question of law and fact. It's ultimately going to be a judgment for the decision maker. But whilst on the face of it, there is a different size, permanence, degree of physical attachment, the planning law test doesn't consider on the face of it the purpose of annexation. What's interesting is how it might be applied in practice. And the way that Lord Carnworth, for example, considered reclining woman and considered the Crystal Palace dinosaurs, he was applying the planning law test, but he was actually focusing on the reason why they had been placed in situ and how long they'd been there. So it was in practice more like purpose of annexation under the property law test. So I wonder if it will depend on the fact, and I'm sure we can think of hypothetical examples where the application could yield a different result, but I wonder if in practice, if that is actually going to result in a different answer in most cases.
Yes, I think I'm inclined to agree. I mean, when I've been advising on statutes over the years, I've usually looked at both tests because pre-Dill a degree of caution was required, and come up with the view it doesn't actually make a difference in the particular outcome. Interesting enough, in Dill, the Supreme Court said that the Piers and Urns would not meet the private law, the land law tests, and left open whether they were buildings in the planning process. I suspect quite a bit of that was that the planning question was one which was intended to go back to an inspector court. What happened in the end was that the Listed Building Enforcement notices were withdrawn. So the Supreme Court thought they shouldn't trespass on that territory, but it seems to be usually you'd get the same result, and that may apply in one of the sort of situations which raised by one of the questions which has come in about items which are on loan. It's not unknown to have publicly displayed statues which are on loan for a very long time. But the fact that they are on loan seems to be relevant to, on the landlord side, the purpose of annexation, and on the definition of building to the question of permanence, because a loan item is, by its nature, not necessarily at least going to be there permanently. Moving to one question, which is the relevance of the contested heritage issues to listed building or planning decisions. And one aspect of that is that to be material in planning terms, it needs to be something for a planning purpose. It needs to fairly reasonably relate to the development that's permitted and not be irrational, take it into account. The Supreme Court in Wright and Forest of Dean in 2019 is the most recent case on that. Now, where there is a dislike of the particular individual memorialized, one question, it seems to me would be whether that actually is material in the decision-making process. And I was trying to think what cases there were which could give a guide on that. And the only ones that I've managed to come up with are a series of cases which concerned sex establishments. And in those situations, which are mainly sort of 1980s cases, so there's a bit of dating in how things are dealt with in those, where the Secretary of State or inspectors are upheld by the courts were prepared to refuse permission because they thought that a particular establishment would make a particular location unattractive and rather discourage many people from going there. So not a question of the Secretary of State saying he doesn't like these sorts of establishments, but of the Secretary of State or the inspector saying, well, there is actually a land use impact because this particular establishment, where it would be, is going to be affecting the desirability of letting out flats above it, or of going down this particular alleyway. And there may be situations where the presence of particular statues can actually be so offensive that it has a discouragement to a sizable section of the population. I think that may be a different, in sort of relevance terms, a different question to simply the fact that either doesn't reflect modern values, or that some people take a particularly strong dislike. But I think we'll have to look into those issues are going to be sort of coming up into the decision-making process as it works through. Okay, another aspect that seems to arise potentially is the public sector equality duty. And I don't know, Catherine, you have any thoughts as to how that may bear on decision making?
Yes, I think the public sector equality duty could well apply to the sorts of decisions that local planning authorities and the Secretary of State may face in the context of contested heritage. And it's a duty that applies whenever a public body exercises one of its functions. So it could well catch a decision whether or not to grant listed building consent for, if required, for the relocation of a statue or memorial, or indeed a decision to delist it. I'm not saying it would necessarily apply in all those cases. You'd have to consider whether that decision raises any equality issues, whether it has an impact on any groups with protected characteristics. There's a huge amount of case law, not much of it in the planning context, about what triggers a duty. But I do think there's a real likelihood that it will be triggered in contested heritage cases. But I think, although the public sector equality duty for public authorities is often seen as a bit of a thorn in the side because it can be, or it's perceived as being quite onerous, I do think it could be quite a useful tool in this context to address what are really tricky, by definition, contestable issues. And what the public sector equality duty does, it doesn't require or dictate a particular answer to be reached because it bears on groups with protected characteristics. What it requires is the decision maker to pay due regard to the public sector equality duties, and there's guidance and case law explaining what sort of steps a decision maker should take to pay due regard, and that can involve anything from a formal equality impact assessment and through to simply applying the decision maker applying his or her mind or its mind to the issue. What can be helpful is to engage the public in this issue through consultation, formal or informal, to gather information about the nature of the impact on protected groups. And all of that could be, I think, a quite useful tool for addressing these indisputably very tricky issues.
I think that sort of seems to be behind some of the thinking, that the need for engagement and need for a sort of reflection of, the impacts on the public and what the public think behind the need for a planning application, and also a greater ability for the Secretary of State to call in where there are heritage objections being raised, so that there's a planning decision-making process that's engaged in it. But it seems not to be a sort of a trump card, nor looked at in the heritage context. Question then is really how we take these points forward, and where the balance goes between retain and explain, or remove, or look at other ways of addressing some of the issues. Where do you, perhaps Antonia, where do you think the balance would get struck?
So there are clearly two issues here, aren't there? One is the statue and one is its location. And so if we're looking at preserving statues but maybe changing their locations, then we're making decisions about how we use space and how we make democratic decisions about that. So the planning process strikes me as a sensible way of doing it. I mean, anyone can apply for planning permission, so that would be a way of triggering debate should you want it, but you'd want the right test case, I'd suggest. And what that would mean then is that you might have some kind of data on which kind of people are calling for its removal and who would like it remain. So that might be a way you could evidence your duties under the PSED if that's what you wanted to do. I think you've probably seen that this week the Mayor of London has announced his Commission for Diversity in the Public Realm, and I think they will clearly be considering whether or not to apply for relocation or removal of some statues in London. And you can see the democratic process in that. You can see that there's a committee. I'm always slightly nervous about art by committee. I suspect many people will be, particularly after the Wollstonecraft decision. But in Bristol, for example, you know, we built a fantastic, or we didn't, I wasn't here, but Brunel's Bridge over the Avon was itself the result of a competition. Now, the first competition he didn't win and the bridge didn't go ahead, and then the second competition he won. So I think design by competition with democratic involvement can produce some really amazing works of art, and the Victorians were clearly highly skilled at this. So I think there are ways of bringing in democracy and balanced decision making, but I think, again, we need to link up the listed building regime with development of a dynamic public realm. And just because something is there doesn't necessarily mean it should stay in the same place. The statue itself may still be preserved, but it may not necessarily occupy the same location forevermore.
I mean, I think there seems to be sort of two aspects to it. One is how we deal with what we have, and then it's what more do we have. And in terms of what there is, it seems to be the level of in a sense the reasons why we protect the historic environment, because it is part of what we live with, is part of reflecting our history and perhaps all its respects. And there's architecture and just immense aesthetic interest very often in that, are all reasons towards preservation, but with, if it comes to it, degree of explanation. It seems to me there may well be some memorials which are so, frankly, so ill judged that something might need to be done. But as a general rule, one of the nice things about history is there is so much of it. There are so many things to look at it, and so much of a balance reflecting the fact that all of us are, as human beings, reflections of our time, and are all flawed in different ways. So if we just had the saints, we'd have a rather sort of more limited lineup. But perhaps the broader point, the way of addressing a lot of the issues and making the public realm reflective of what modern Britain is, as well as what Britain has been, is to actually have more statues, more art, more whether they're memorials or references to life and to people, and to be doing that in a way which, by the people represented, is reflective of both what this country is and the people who live in it, and also what values we see as being important. And of course, in the Colston example, there's a statue erected long after Colston, because those who erected thought that he was somebody worth memorializing. Who we think is worth memorializing now is not simply going to be a matter of recent people. I think the most recent Prime Minister to have an outdoor statue is Harold Wilson outside Huddersfield Railway Station. I'm sure others are going to follow, but reflective of who we do want to memorialize. So I think the most recently there's been a statue of Lily Parr as one of the early great women footballers, but that's in the Football Museum in Manchester. I don't think there's an outdoor statue of a female footballer, possibly not even of a female athlete in this country. There's an awful lot to catch up with in terms of the sort of characters who we see as reflective of 21st century Britain's ideas, as well as those reflective of earlier ideas.
On that point, Richard, I'd come back to a question of who pays for these statues. So many Victorian statues paid for by public subscription are sometimes subscription failed, and required philanthropy, in inverted commas, from a particular individual. And you have that threshold to erect a statue, to pay for the land, or to persuade the government to give away the land, and then to put up the installation. So there is that threshold. And when we use terms such as we need to be careful to recognize that something needs to be done to pay for statues. If we want to change the public space, then there's something that, whether it's crowdfunding, whether it's through public subscription or modern equivalent, it needs to be paid for. And that is maybe an unattractive, but it is a reality.
Yeah. Okay. It needs to be paid for. It needs to be thought through. It needs to be 21st century. thank you everyone for joining in the discussion. Thank you to Catherine, Antonia and David for taking part. Thank you for everyone who's been joining us and for questions which have come in, not all of which we've managed to pick up, but we appreciate all of those. The slides and the recording of this will be on our webinars archive coming up in the next day or so. So please feel to catch up with those. We will be releasing the discussion part of this as a podcast in due course, and we have plenty of podcasts on our website covering areas such as planning, construction, civil litigation. So one about cycling called Wheel Life, and do look at those on our website or on Spotify or Apple podcasts. But thank you everyone for joining us, and this discussion will continue on and on. Okay.